Thank you everyone for coming. It's a Tuesday evening. This is a good way to start the week, I think. Investigations. We've got a good session planned tonight between myself, Jennifer and Dawn. We'll be taking you through why you may need to hold investigations at work. We'll be taking you through the legal framework and responsibilities of investigating incidents at work. We'll look at the purposes of conducting an interview investigation, how we may think about questioning in an investigation. Dawn will take us through how we put an investigation report together, as well as some common pitfalls. And then after that, we have a series of 4 breakout rooms where we'll give you 4 scenarios to discuss how you might handle them. So before I hand over to Jennifer, I'll introduce myself. I'm Pete. I'm a member of the CIPD Essex and Ipswich branch. I work as a HR person in the London Metropolitan University. I should really be able to say that quicker than I do. My role is in the Employee Relations Department, and I look after HR projects and workforce. Previous to that, I've been a line manager at a national retailer for 20 years, 15 of which have been in management. So I've been the line manager at the other end of the phone, taking guidance from HR whilst carrying out investigations. Jennifer, would you like to tell us a bit about yourself as well? You're muted at the moment.
Yeah. Thanks, Pete. I knew I'd do that. So I'm Jennifer Livings. I run Silk Helix, a HR consultancy. I've been doing HR consultancy for small businesses for well over 10 years now. Was with Kroner and Wirehouse before I set up on my own 2 years ago. And yeah, that's me. I'll hand over to Dawn.
And I'll remember to unmute myself. I'm Dawn. I'm HR professional, qualified many years ago. I'm currently doing a programme management role though, so HR projects as well as other projects for the Diocese of Chelmsford, which is the Church of England.
Marvellous. Thank you very much. And I now shall hand over to Jennifer, who is going to start with why should we hold employer investigations?
Okay, so I've just shared my screen, so hopefully you can now see the slides in front of us, and I am unmuted, so you can hopefully hear me too. So yes, managing investigations and why we investigate is a starting point. So investigations come for, largely around disciplinary and grievance. That tends to be where we're most likely to come across investigation situations. We can see here about establishing the facts. They're our basis for a fair procedure under the ACAS code. So if we've got the ACAS code of disciplinary and grievance, the expectation is that we will make decisions based on a full and thorough investigation. A lot of the kind of basis for that and basis for decision making goes right back to kind of British Home Stores and Birchall case 1978. We're still talking about that one, but really it's around making sure that we've got a reasonable investigation, that as an employer we've got a reasonable belief that's based on reasonable grounds that the individual is guilty, and it's particularly important if we're looking at a dismissal and potentially avoiding an unfair dismissal claim. Whilst the ACAS code of practice is no longer statutory, hasn't been for many years now, there is an obligation on tribunals to have a look, to consider whether or not the ACAS code has been followed. Tribunals will look at whether the employer acted reasonably based on the ACAS code, as well as kind of the individual employer, and has the potential to increase compensation when the ACAS code hasn't been followed. So it is important that we're kind of using that as our basis for our procedures. And of course, it's not only the legal framework, but it's also our internal procedures that are being looked at. So if we've got internal policies and procedures, the obligation is that we will follow them. And of course, individuals will also expect us to act in line with our own processes and procedures. So it's really important that those processes and procedures follow our kind of company culture, meet with employees' expectations, because if you're going to avoid not only a tribunal, but also kind of disgruntled employees, that feeling of fairness, it's really important that people feel like the procedure followed actually fits kind of what they would expect from that organisation. And of course, if you're writing the procedures, as many of us are in HR, making sure that you don't write procedures that can trip you up, because that's a kind of common error, putting so much detail into the procedure that we end up tripping ourselves up by our own internal procedure. So there's always a balance to be had there in terms of having a procedure that kind of covers what we need, but doesn't go into so much detail that we can catch ourselves out with our own procedures. So that's kind of where we're at with the basis of kind of why we're doing an investigation. We're making sure that we've got that fair process, that we're meeting with the ACAS code. In order to get that fair process, we need to make sure that we've got an investigator who knows what they are doing, understands the process, and understands how to conduct an investigation. And this is really what we're going to be looking at tonight. And as we probably know through the ACAS code, we're expected to have 3 different people involved. Should it go to appeal, of course, so we would have an investigating officer. That person should be different to the person that makes any disciplinary decisions. And we should have somebody available to take an appeal if that's needed. And of course, that for small businesses can be quite challenging to get those 3 different people. And that's one sort of the relief of having the ACAS code no longer statutory, is that there is some sort of flexibility there if we need it in terms of reasonableness. But of course, where possible, we should be looking to have 3 completely separate people involved in the full procedure. So the investigating officer, their objective is to conduct a fair, completely unbiased investigation. They are purely there to gather the facts, not to make decisions, but to gather the facts. They're there to look at who witnessed the event, misconduct, whatever it is we're investigating. They may also look to other forms of evidence, such as documentary evidence, CCTV evidence. It's also their role to keep the parties informed of what's happening in an investigation, particularly the individual that's being investigated. It's their role to inform them and to make sure that everything happens in reasonable timescales and that people are kept updated. And then their responsibility to sort of produce a report and make recommendations. Now, those recommendations are limited. And I know Dawn's going to touch more on this, but it's really important that those recommendations don't go any further than potentially this is a disciplinary. There should be a disciplinary hearing, or there is no case to answer. They certainly should not be making any kind of decision around the disciplinary outcome that might come from this. And there's a potential for a dismissal to be unfair if an investigating officer takes more of the decision making than they should do. And of course, one of the key things that they could be looking at is whether or not the person we're investigating needs to be suspended during the investigation. And reasons for suspension, things like relationships have broken down, where there's a potential for we're dealing with gross misconduct, where there's a risk to the employee or company property, where there's a risk to the investigation and the evidence. We may need to suspend someone in order to preserve the investigation. Employers should always look to alternatives to suspension to avoid it. Can we move this person to other duties? Can they work from another location? Are there ways that we can avoid suspension? So where possible, we should be looking to avoid it, but we may have to use it, and it's a tool that's there if we do need to use it. Do remember the suspension is always on full pay and should be for the shortest amount of time possible, and the individual should be fully informed in writing of the reasons for their suspension and kept informed of timescales and as things kind of progress throughout the investigation. So I shall hand over to Pete, who can talk us more through the investigation interview.
Marvellous. Thank you very much, Jennifer. So, yes, I will take a look at conducting investigation interviews now. And really, the conducting of an investigation interview hinges around the purpose of it. And as has been mentioned already, the purpose of the investigation interview is to establish facts. It's not to apportion blame. It should not turn into a disciplinary meeting. It's purely to understand what's happened, to establish facts, to gain information from people who have been involved or who have witnessed an incident. So there's an important part of that, which is collating the evidence. I would say we have a duty to record what happens in an investigation, and we do not have a duty to take verbatim notes. We do not have a duty to write down every single word which is said in an interview, but we do have a duty to make sure that the notes we take are a fair and accurate representation of what happens. Now, an investigation is actually an informal event, which means that legally people do not have a right to be accompanied if they are attending an investigation. However, having said that, there are instances where people may be able to be accompanied when they're attending an investigation. They are, if your company's own disciplinary and grievance procedures allow that, but also consideration should be given to the Equalities Act and whether you can allow someone to be accompanied as a reasonable adjustment. And instances where that may prove useful is if you're having to hold an interview with someone for whom English is not their first language. Other arguments for doing this is that it makes people feel at ease, it can support employee well-being, and some people have found it can actually mean that people are more willing to talk in an investigation as well. Now, thinking of the structure of our investigation meeting as well, we would want to make sure that anyone attending is certain of the purpose of that meeting, clarifying that it's to find out facts. We would want to go through a process of questioning to obtain the facts that that person may have. We'd also want to make sure that at the end of the meeting, we are able to summarise those facts so that they are agreed and make sure that people know what's going to happen next. But the preparation actually starts before the interview commences. So before the meeting takes place, the person conducting the interview needs to think, who am I interviewing? What information may they have? How is that pertinent to the event that I'm investigating? And how am I going to handle the questioning? It also includes administrative tasks like booking an interview with somebody. It includes writing to them to invite them to that interview as well. When we get to the start of the interview, there are some things that we need to do to make sure that all our interviews are consistent. For instance, we would make sure that people are introduced, that the role that they play in the meeting is clear, that we clarify the role of an investigator, the purpose of the meeting, and the need for confidentiality, that what is spoken about inside the meeting doesn't get discussed outside of it. That could jeopardise the investigation. We would also like to tell people how their witness statements may be used and who is going to see them. And then it's during the investigation at that point. So if we can move on to the next slide, please, Jennifer, we have some examples of questions which may be useful during that. So there's some examples of questions here that may well help you. There are an awful lot more on the ACAS website as well. But during the interview, we could use these questions or any other ones that are pertinent to try to ascertain facts. We're looking to find out what happened in an investigation. We can use questions to probe the interviewee without trying to be adversarial as well. So we can use the questioning to ascertain whether or not what we're being told is true and accurate. As said previously, we can record these as well. And that may vary from institution to institution. Some places will provide to have a note taker, so an investigator can simply concentrate on handling the investigation and following a train of questioning. Other organisations may expect the interviewer to take the notes themselves. So when we've had the questioning towards the end of the meeting, we need to make sure that the person being interviewed has got a chance to give us any other information we've not asked for, and chance for them to ask questions as well. It's also advisable to ask if they know of anyone else that they think should be interviewed as part of the investigation. And I would also say, because when we're conducting interviews and investigations, more information can come to light later, I'd recommend advising people that they can be re-interviewed later if need be as well. And also we need to make sure that the record we've taken of the interview is agreed to be a fair and accurate representation of that conversation. The way I handled that when I was investigating was to make sure that the interviewee had time at the meeting to read through, to clarify any points in the notes, and to actually sign and date the bottom of each page. I would try to make sure that my notes didn't have any long spaces or blank pages, because that would mean that the investigation could be open to allegations of being tampered with once they've been signed. So that's a relatively brief overview from me of how we may handle an investigation interview. I'll now hand over to Dawn, and she's going to take you through an overview of the investigation report. Thank you.
Hello, right. Yes, the investigation report is written after the investigating officers completed everything that they need to do. So everybody they've spoken to, or the evidence they've gathered. The report should cover the basics that you can see on that slide. And the conclusions and recommendations need to be careful on what is concluded and recommended. In other words, it has to be based on fact. So the investigator officer shouldn't be given an opinion, or if there wasn't enough facts to support it, then they have to say that in the report. They can't go, this is based on what I feel. The recommendations should be considered. In other words, they should only be really whether there's enough evidence to proceed to the next step. So the next step would either be a formal, informal, or no further action. I'm aware that in public sector, the investigating officer sometimes is given a bigger role and sometimes is asked to make a recommendation. ACAS doesn't support that. ACAS recommends that the investigating officer just investigates, and it's for the hearing, the chair of the meeting to actually make the decision on what the outcome is. It's literally just based on facts, whether there's anything else to respond or not. Something else to be mindful. In March 2014, the Supreme Court ruled that there was an implied contractual right to a fair disciplinary process as a serious breach of which could enable an employee to obtain an injunction preventing the employer from completing the process without starting again. In the case Charborough v West London Mental Health NHS Trust, this implied right was breached because the conclusions of the person investigating the allegation against Charborough had been amended extensively by HR advisor. So I think there's a big warning there, is do not tamper with your investigator's report. It is what it is. Now, again, down to your own personal processes and procedures. Some companies will share the investigating report ahead of a meeting. Other companies won't share it unless it goes to disciplinary. But again, obviously, compared to your own procedures for that one. Can you go to the next slide, Jennifer? Thank you. Right, so common pitfalls. These are just a few. The other big one is not incomplete investigations, so not gathering all the evidence, not talking to the witnesses. There's also a discussion point about who should you investigate first. Should it be the person at the centre of the investigation or others? Again, it will depend on your case, but maybe better to do the person last once you've got some other evidence in case there's questions you want to ask. One big thing that a lot of people do is they don't consider those involved, whether they be the witnesses or the person being investigated, as you still have a duty of care to those individuals. So be mindful of that, especially if it's potentially a disciplinary. There might have been an allegation that turns out to be false. So you've still got to look after that employee, because you've got to work with them after this investigation's completed. So I think that's it. I think we'll now move on to our scenarios. I think, is it over to Jennifer, or is it, I can't remember, it's Jennifer or Pete?
I believe the first scenario is for me. And in a moment, I'll be adding you into breakout rooms so that you can discuss this. And then when you come back, we'll ask for feedback just from a couple of rooms from this as well. So the first scenario is this. You work in the HR department. A line manager approaches you with concerns about Robert. Yesterday, Robert returned from his lunch break smelling of alcohol. His eyes seemed a little glazed, but he was coherent and didn't appear drunk. The line manager also mentioned that they've noticed Robert's performance has dropped. Nothing specific, he simply doesn't seem to be on top of things like he used to. The line manager has previously spoken with Robert, and Robert's assured him that everything is okay. So I'll pop you into breakout rooms, and there'll probably be about half a dozen people in there, and you will have probably 7 or 8 minutes to talk through what would your first steps be.
Yeah, so within our group, we discussed obviously our response to this. So we thought having, a conversation with, the manager as well, initially to see what, has been said before to Robert, and having an informal chat with Robert and the line manager, with the focus kind of like on the performance, and also, one, there could be other issues going on, but secondly, it may not be alcohol. They could have smelt something else, but if they made this assumption that it's alcohol, so we kind of felt it was really important to not make any accusations, or accuse Robert of anything until we've had a discussion and had a chat with him to establish the facts. So that was kind of like our thoughts on this issue. So it's like, looking on the performance.
Thank you, Andrew. No, absolutely.
We said it would depend on the organisation and whether they had a policy about drinking alcohol at lunchtime, and it would also depend on the nature of the job that the person did, whether that was going to be a serious risk. We also talked about it might not have been alcohol. So our first step was to know, is there a policy about this? So has a policy been broken? And the second step would be for HR to advise a line manager to have a more, not formal, but to have a discussion and document it, to get the facts right, to find out whether there is an issue or not. The fact that the performance might have dropped may be nothing to do with it, or it may be everything to do with it. That's probably the main issues.
Marvellous. Thank you very much. Also, apologies, I don't know, the computer's connected, but occasionally I get an error message and it tells me that Zoom stops working and I have to log back in. Hopefully it doesn't happen later. Thank you so much for feeding back. Apologies that I missed what Andrew had to say. I thought exceptionally insightful to separate the two out. though. It's one thing for someone to smell of alcohol, but at the same time, the performance issue may well be completely separate, completely independent of that. Jennifer, Dawn and I spoke it through, and we came up with a few things that we thought would be important to cover. One being, what's the line manager already done? What's the conversation with Robert been like? Is an investigation needed? And as was said then, that will come down possibly to policies in the organisation, and then appoint someone as an appropriate investigator. So yeah, brilliant, thank you. I'm going to hand over next to Dawn, who's going to take us through scenario 2, which actually follows on from this scenario. And then again, I will pop people into breakout rooms, and I will keep my fingers crossed that Zoom doesn't crash whilst you're in there.
Thank you, Pete. Right, second part of this scenario is one of Robert's colleagues witnessed Robert returning from lunch, smelling of alcohol, and you overheard her say this was not the first time. She's reluctant to get involved and doesn't want to say anything on the record. How are you going to deal with this reluctant witness to something that's potentially, or may not be, depending if it smells of alcohol or not? So you can pop us into our breakout rooms now to discuss. Right, I'm going to pick on room 4. Might as well go down in order. So anyone in room 4 wants to give me any feedback? If anyone can remember that they were in room 4.
Yeah, I was in room 4. It's quite interesting. When you've got a reluctant witness, we've had a nice big conversation about it. It's interesting to try and find, you really need to understand why they are so reluctant in coming forward. They might be quite happy to talk about another staff member back in the, over a cup of coffee or whatever, but what is actually stopping them? Is there an issue with their relationship? Personally, do they not see eye to eye? Do they not work well together? Is there a fear of recrimination if they go on the record and they feel that later on down the line, if they've said something, is that going to damage a relationship that they've got? But it's really, the key thing is talking to that witness and finding out why they don't want to speak up.
Mm-hmm. Okay, does anybody else want to add anything to that? I'll open it up to anybody that wants to speak.
I think I made a suggestion in that if someone's unwilling to go on the record with something, essentially if you've overheard someone, there's a possibility that is office gossip, and office gossip can be taken out of context. So you're witnessing someone returning from lunch smelling from alcohol, but you haven't seen necessarily what's happened. And sort of going on to that sort of work relationship thing, if it is gossip and it's sort of innuendo and your relationships are sort of quite possibly negative within a workplace, and you're not willing to go on the record, there's an element of, is that a truthful statement that person's making? So it's always difficult to actually say what is the case in something like this, because you haven't got the specifics within that scenario.
That's true. As we were talking about in the group that I was in, HR, as we know, is not black and white. So every case is different. So you have to look at everything. Don't always take things on total face value. Some of the things that we kind of talked about when we talked about this as a group, myself, Jennifer and Pete, it's about reassuring that person that, you've got a part, you've seen something or you've witnessed something, and we kind of need to know what you saw and heard. Now, it could be office gossip, or they could have genuinely seen or heard something. We need to establish that. We are as a company under obligation to actually investigate this. If it's something where you really need this witness to tell you what they've seen, and it might not be this scenario, but a different scenario, and they really are reluctant, and you've been through the reassuring them, trying to find out why, and if they've got no real good reason why they just don't want to do it, they just don't want to get involved, they want to be a bystander, you could end up going heavy-handed and threatening disciplinary with the, it's a reasonable request from a management. But that's not an ideal solution, because obviously you've got to think about that relationship with that employee going forward. So I think persuasion is the best key if you can, and take it from there. So I don't know if Jennifer or Pete want to add anything to that.
Not from me. Not really well done.
Oh, can I add something? because I've raised it in our group. I wouldn't disagree that encouragement and finding out what they're afraid of should be your first point of call. But you've already mentioned that ultimately it's a reasonable management instruction, and not many people have got a policy that doesn't say refusal to follow a reasonable management instruction won't be treated as a disciplinary issue. But all our clients for the last few years have a specific clause in their handbooks saying you are required to participate in any reasonable investigation. And that might be this sort of investigation, it could be an accident investigation, and saying, oh, I don't want to get involved. I know my colleague lost his leg, but I don't want to get involved in that. It just doesn't cut it for me.
No, I totally agree, Peter. It's around, what policies have you got in there? Have you got that enforcement in there? If you haven't, then it is down to persuading. Persuasion is always the best starting point, probably. Yeah,
absolutely.
And then you go heavy-handed with your policy, and if it's worst case, it's disciplinary, threatening with disciplinary if it's a reasonable management.
And in our experience, it has made it easier for people to say, well, I was only following the rule which the company kindly pointed out that said I had to participate, it wasn't voluntary.
Yeah, it gives them something to hide behind. I didn't want to do it, I'm still your friend. Yeah, totally agree.
Yeah.
Anybody else want to add anything to that till we move to the
I was just going to add something, if that's okay.
Yeah.
It's kind of on the same lines as what kind of Peter was just saying. I was mentioning to in our room that we have on our witness statements at work, we actually have added a section at the top that states that whatever is written on there could be shared as part of possible investigations / disciplinary procedures, and also shared as part of a subject access request. And if they don't tick that box and sign that, then obviously they're not agreeing that we can do that without their consent, and then they could ask for it to be redacted, for instance. If they were we've had a few scenarios where there's been issues between two individuals, that have even caused police investigations as part of it. So it can be quite difficult with people to kind of get them to be reassured that they're not going to then end up on the wrong side of that person. So, yeah, that's what I wanted to say.
No, it's a good point, but I think if it's criminal, the fact they tick a box or not, if that's the witness statement, that will be pulled into criminal. I think criminal overrides employment law and their rights under Gdpr.
Yeah, absolutely. I'm an investigation at work, and then if that person obviously stays and it's not found and they keep their job, they're scared of the repercussions of the person. So that was something that we had added as part of what our solicitors had told us to do, because we have a lot of subject access requests. Yeah, just another side sometimes.
No, it's a very good, valid point. Anything else before we move on to the next part of this?
So could we also then take possible stance here that you could land yourself in a few problems that you're actually pushing a witness to give you some information? So in other words, that the individual that's being investigated could turn around and say, well, I've been made aware that you're chasing witnesses for this.
I think in this particular case, the individual actually, the HR manager, the HR manager, you overheard her saying.
Sorry, I misunderstood.
Yeah. So you overheard her saying this wasn't the first time. So she kind of volunteers information for you. So you're not chasing her. She actually said it. So you're just following up on something she said.
You probably are going to have to chase at some point. If she says, well, there's a bunch of other people there, who was it? Who were those other people? I'm not telling you. Right, we're going to have to go and find out. The idea of, people can accuse you of stuff, but you've just got to be robust enough to tell them that you're handling the investigation and you're not going to let them intimidate other people or yourself out of pursuing it.
Do we need to let the person we're investigating against know that we're doing this? Otherwise, it could be, construed as doing something behind their back.
Yeah, so Maggie, that takes us on to the next scenario. So I'm not going to comment further on what you've just mentioned there, just because I don't want to give away the answers to the next one. But what Stephen said, there's a really interesting point around kind of chasing witnesses, and we have to make sure that we've got reasonable reason to go and speak to witnesses. So we need to make sure it's not a witch hunt, that we haven't just sort of gone round kind of digging for dirt. But like in this case, where we've got evidence that somebody has overheard something or that somebody's witnessed something, then it's absolutely right to go and speak to them, and absolutely right, as Peter says, to be able to say to them, actually, this is a reasonable management request. As a company, we've got an obligation to investigate matters, and it's a reasonable management request to ask you to take part. We expect you to. And part of your discussions, as we said there, with a reluctant witness may be around giving them something to hide behind in terms of being forced to take part, but equally may be more appropriate just to give them the persuasion rather than the coercion. But that's all going to come down to culture. It's going to come down to the individuals that are involved. It's going to come down to the nature of the case. All of these things that we take into account. And then an interesting one there about GDPR. And obviously we do have to remember that consent isn't the only legitimate reason for processing data. And as employers, a lot of the things that we're doing don't require consent because we've got other legitimate reasons for processing that data. So be cautious about using consent where it's not where somebody sort of withdrawing that consent would actually cause us a problem, and therefore another reason might be more appropriate. And I'll take that on to then scenario 3 there, as Maggie started to sort of point out and raise. So as part of the investigation, you'll need to speak to Robert. And how would you plan to do this as part of the investigation? So we'll put you back into your breakout rooms. I'm hoping, yeah, Pete's there, good for you. We'll put you back into your breakout rooms to have a discussion about kind of how you would handle the investigation with Robert. Brilliant. Okay, so yeah, you've been discussing how we deal with the investigation with Robert, and where in particular, sort of, where we put him into the conversation, into the investigation. So, does anybody want to share with us what you've discussed?
Okay, we're here from room 4. We talked about, depending on what Robert does, we would speak to Robert. I think it's good for him that Robert finds out from us, because depending on the size of the company, you never know what gets out. Also, that we don't know what Robert does. Robert could be a driver for our company, and then we would be considering suspending him or moving him into another job while the investigation is going on.
That's a really valid point in terms of taking the specifics of the situation into account. And yeah, as you say, if Robert's a driver, it's going to be a very different situation to if he's got an office-based role. So absolutely. Does anyone want to add anything to that?
It's Matt. We was in group 7, and I guess to contrast that, me in particular was kind of conflicted with that. Is I work in the banking industry, and it's really normal for a relationship manager to have a glass of wine with their lunch, meeting a customer or entertaining a customer, or being at an event. So, you know, as part of the line of questioning, it's really important to keep an open mind. And while we're not saying it's okay to be drunk at work, actually, have they just met a customer and had a glass of wine, and does it need to be a different kind of conversation entirely?
Yeah, absolutely spot on. The situation that you're in is going to really depend on whether this is even a disciplinary situation at all, or something completely different. So, no, absolutely.
This is Steve from room 5. We're sort of similar to that about wanting to get somewhere with Robert. It was that hard question as to you say something before or after, and in a small organisation, it's going to be found out. So one of the ways I've done it before is you can actually have an initial meeting with Robert, perhaps not do a fully scripted investigation, formal meeting with him, but at least get some information from him, make him aware that this issue has come up, get some statement from him, say to him that you're meeting other people and that you'll probably look to meet with him again at the end. So in other words, you sort of try and counter those sort of rumours getting around the business when people keep disappearing out of the office into meeting rooms and everyone starts going, what's going on and why is everyone disappearing? So at least you break that, but then linking in with what the guy just said there is about, you might want to get some clear facts from him because he might turn around and say, yeah, I have been, yes, I've got a problem. During which point are you then going to necessarily don't want to go through the formal investigation process if he's already sort of part of the expression rolled over and gone, yeah, fair cop, I've got a problem, and then you're into the whole welfare, you're into the welfare side of it.
No, that's exactly it. Thank you, Stephen. And as you say, it is about trying to make that judgment as to when we get somebody involved in the investigation, and do we do that at the beginning? If we do that at the beginning and then more facts come to light, we may end up sort of re-interviewing them and having to speak to them again later. If we do it later on, as you said there, Stephen, things can kind of leak out, and or you get that feeling that something's going on that's not particularly pleasant to be in. And so it's about trying to make that judgment as to when is the right time to have that conversation. And again, that's going to depend on the facts. Often it is useful to gather all the facts before you have the investigation meeting with the individual, but that may well, yeah, as you say, depend on whether actually this individual could just clear up the matter right at the beginning, turn the conversation, and we don't actually need to take it any further. So it's trying to take every situation on its merits to look at how we deal with that. The ACAS code does say that we should inform people at the earliest opportunity that we are investigating them, so they should be aware of that. But again, even that will come down to taking into account specifics. So if there's a risk that by telling them that you're carrying out that investigation, that potentially they're going to interfere with that investigation, then that may be something that you want to take account of. And of course, whether or not you're suspending them in a situation like this, we're not necessarily looking at suspension. But if we were, then that may play a role as well as to kind of whether we have that conversation before somebody goes off on suspension or later on, or planning two conversations, one in the early stages and then one sort of further down the line. So I shall hand over to Pete for the final part of our scenario.
Brilliant, thanks, Jennifer. That last point about taking everything into account really does lead on very well to our fourth and final step in this investigation. So at this later stage in the investigation, we've now found out from another colleague that Robert has significant challenges at home. His marriage is currently breaking down. So what do you do with this information now? How does this impact your investigation? Would anyone from any of the rooms like to share how this might affect the investigation or how they may handle it?
I was in room 2. It's Sam, by the way. I was in room 2. So we kind of felt that it's moved from an investigation into more of a well-being. You know, obviously he's having problems at home. Is there anything we can then do to support him with those problems? He'll either do one of two things. He'll either, the barriers will go up and he'll go, no, fine, I'm okay, or he'll just break down. So depending on the kind of reaction you get, you know, we're offering you support as an organisation. We're here to support you. And kind of approach it that way. But as far as the investigation is concerned, I feel that, you know, that's null and void. There's a no further action on that.
Okay, thank you very much. So we've got more understanding around what may have triggered Robert's drinking. Starting to think more about welfare and well-being and support rather than a disciplinary, and a suggestion that it might mean that the investigation ends. Does anyone have anything else that they'd like to add there?
Oh, hi, I'm Donna. I was in room 6.
Hi there.
We agreed with the well-being side of things and the support. However, we were still conscious that depending on the policy, the nature of the job that that Robert is doing, it would depend on where you would then take it. You know, if he was operating machinery or driving, for instance, you would then have to look at that separately, because obviously it could be gross misconduct, regardless of this, you know, of what he's going through. However, obviously that's mitigating circumstances, and you could take that into account as part of any disciplinary, and as well as having that support at the same time. And then you could look at moving him to an alternative role for the time being, until you ascertain if there is an actual issue going on that's going to be ongoing, or whether it's going to be, you know, you could involve occupational health as well, just to kind of get all of that in place so you understand a full picture.
Marvellous. Thank you very much, Donna. So an added dimension to an ongoing investigation there, and mention that potentially the personal life could be mitigating circumstances at a disciplinary hearing later. Do we have a third person that would like to offer a viewpoint at all?
We just had the consideration that he may be a drinker. He may have a drink problem, and that is actually the cause of the marriage breakdown. And therefore, we need to take the whole picture into account and think about the circumstances of his role. And I guess I'd be encouraging the line manager to be having discussions with him about how's things at home, and, you know, what you're doing to look after yourself, so that we can try and ascertain, did the drinking come before the marriage breakdown, or is the drinking subsequent to the marriage breakdown?
Thanks very much, Patricia. I think that's really insightful, and it's not actually something that I had thought about personally, because you read scenario 4 and it's very easy to assume that the drinking is a result of the marriage breakdown, whereas yes, it could be the other way around. Absolutely correct. When Dawn, Jennifer and myself were talking about it, we thought that the information would not really be enough to stop the investigation, because the investigation's done without prejudice. It's about finding out facts. This is a fact to be included in the investigation report, and that the information should go into an investigation report. Bearing in mind, we can always talk to Robert again if we want further clarification, and that if, and the investigation isn't a disciplinary, but if it goes to a disciplinary hearing, that the personal circumstances may well warrant mitigating circumstances, and it could change the outcome of a disciplinary hearing if it were to go that far. But I wish I was in some of the breakout rooms, because the feedback and the conversations afterwards are really interesting, and thank you so much for joining in. I do hope that you found the evening interesting and informative, and we do have some time. If anyone would like to ask any questions, you could put them in the chat, or if you'd like to, or you can talk as well. But we do have a bit of time to take some questions, and we will do our best to help answer them.
Can I just ask about investigations? It's Anne speaking, sorry. Investigations at the moment through this pandemic, and obviously there's some challenges at the moment because investigations are having to be carried out remotely rather than face to face. Are there any sort of tips and guidance that you could give in those kind of situations? Because I've had some managers that are concerned that they've offered somebody, you know, the right to have a colleague present with them as part of an investigatory. The person's declined having a colleague, but then the manager's concerned that they've got their husband or their wife kind of in the background of the room with them on Zoom while they're doing the investigation. So are there any sort of tips and guidance on sort of carrying out investigations at the moment in this current scenario we're in?
That's a really interesting one. I've personally been involved with carrying investigations out during lockdown, but it has been contributing data evidence with the ones that I've been involved and someone else doing the interviewing. I don't know if it's something that Jennifer, Dawn, or anyone else in the room has dealt with.
Yes, I not actually since in the pandemic. Actually, we've sort of managed to either avoid them, or they've been in the care industry where they've carried on site anyway. But I, in my previous role, was a witness in an investigation when I worked remotely, and the investigation was carried out by phone. And it was just before the days that we were using Zoom, we were just doing everything over the phone. And it, similar to other meetings, it was just booked as a meeting. And in that situation, we didn't have the right to be accompanied. I guess that's one of the challenges with the right to be accompanied, because even if somebody is accompanied and got that presence on Zoom, that's going to be slightly different. Obviously, there is no legal or statutory right for accompaniment for an investigation, but if your policies and allow that, then that's going to be there. I think one of the things, I mean, I've certainly done redundancies over Zoom, and certainly said then to clients that actually we can't stop somebody being in the background. We can't. I mean, there'll be many a partnership and adult children and young children working at the same desk at the moment. We can't. We've got no physical way of stopping that. I think reminding people around confidentiality is really important. I think we have to understand the reality is that if people are involved in something challenging at work, they're probably going to go home and talk to their partner about it anyway. So I think in many ways, in terms of confidentiality, there's probably not much more than that happening in terms of where people would go to their partner for support. I think the main thing is making sure that person doesn't get overly involved in the meeting. And certainly when I've allowed parents or husbands and wives to attend disciplinary meetings over the years, they can occasionally be supportive, but more often than not actually end up emotionally involved in something that actually makes things worse. So I think managing those things can be quite challenging. I mean, certainly during the pandemic, it's kind of doing our best. I think it's going to be a little bit harder as we go forward with more remote companies and people that work remotely all the time. And certainly when I was part of an investigation previously, we were remote all of the time. So I was a 3-hour drive away from the office. Bringing me in for kind of a 20-minute chat just wasn't realistic or practical. So it is working around kind of the situation, that we're facing, how near people are, whether you can bring them into the office for that investigation or whether you do it remotely. But I think it is going to be, like most of these things, a bit of a case by case. And what you've come across, Dawn?
No, I think the same. I'm like you. I've only done redundancies through the pandemic remotely, and I didn't have any issues. But I can understand why your line managers feel uncomfortable, and they're dealing with people in the background. They don't know who they are, what they're doing, or why they're saying it. But it's not, unless you can do it where you can do face to face, whether it's an outdoor meeting, sitting, if your office has got a garden or something, or there's a cafe, you can do it. The only other way to do it is by Zoom, and we just have to put up with. And I guess the notes of your meeting might say that we believe there was someone else in the background, but they didn't declare who it was. That's all you can do.
Just so I've had to do quite a few because we've been required to work from home for the last year now, so I actually haven't been in the office near enough for a whole year. and we've changed our policy. Well, our policies remain that there's no right to be accompanied. What we've done in the invite notices, we've now put in, you may have someone with you if you wish. So we've just changed it that way round. And then when we've had a few requests for parents to attend, because we've got some younger staff that work for us, is we've allowed them, but we've made it very clear in the sort of letter to them, say, by exception, we're letting you have this because of the circumstances we're currently in. We're allowing this at this particular time. And a bit as you've already said, that we laid the law down quite clearly at the beginning of the meeting as to the role that person has is they're there to support you, not to be addressed in the meeting. So we're much clearer about what our expectations are of that person in the meeting. It has tended to help us. But like as you said, we had no idea if other people were sitting in the room. I had a 6-hour investigation meeting for a grievance, and I'm pretty darn certain there was someone else in the room. There was no way I could prove what was actually going on at all. So it was like, to sit there on a Zoom call for 6 hours and let the person talk was what I ended up having. So
no, I think that's a very good point, Stephen. I think it's that, asking them, are they going to be alone? Have they got someone with them? Do they want to sort of, by all means, they can be accompanied by a family member, but it'd be nice to know that they're there, introduce them and just explain what their role is, that they can listen but not really take part. Any other questions? We're mindful of time. It's now 8:30, so we said we'd finish at 8:30. Has anyone got any other questions they would like to ask? And we'd like to thank you for coming tonight. So no more questions. Well, thank you very much for attending. It was great to see everybody. I think we were a bit overwhelmed by the amount of surprise, amount of people we had apply tonight. We try and pick topics that people want to listen, but if you've got ideas, please let us know at CIPD, because we have to rack our brains to think of great subjects to give you, so we don't always get it right. That's great. I don't know if Jennifer or Pete want to say anything before we finish.
I would just reiterate, thank you everyone for taking the time, taking a sizable chunk of time out of the week, at a busy period, to come and to contribute. It's been a pleasure to see everyone, and I hope you've enjoyed and benefited from the evening as well. Thank you.
Thank you very much, everyone.